This is the PowerPoint video for Chapter 11, and just a reminder that all images and videos are in the public domain. This chapter deals with the issue of judicial review in the famous case Marbury versus Madison and the midnight judicial appointments by John Adams. It also deals with Jefferson's Lewis and Clark expedition, Jefferson's Louisiana Purchase, and it also touches on the Barbary pirates, the pirates of the Mediterranean Sea, and the way Jefferson handles this conflict with France. So this is the triumphs of Jefferson's Republic, Jefferson's presidency, and that should be 1800 to 1812, not 1912. So in the election of 1800, we actually have the first presidential election where an incumbent, John Adams, is challenged significantly by Jefferson. So you have the Democrat-Republicans and then John Adams. And so the first two elections, John Adams, I guess, was second place in the election, but George Washington was never seriously challenged. But in this case, you have Thomas Jefferson challenging John Adams. And when Thomas Jefferson wins the election, it looks like, or Jefferson describes it as a peaceful revolution. So Jefferson claims later that the election of 1800 was a revolution comparable to that of 1776, when you have a situation here where it's the first time in history where somebody actually wins an election and the sitting ruler, or in this case the sitting president, voluntarily steps down. So it's very close vote, within 250 votes in New York. This would have been a switch then in the Electoral College. So if you look at New York and the 12 votes here, if you switch the 12 votes in the Electoral College, then that gives the vote, that gives the election then back to Adams. So very close. But nonetheless, Jefferson wins, and Jefferson claims this is no less a revolution. It is peaceful, and it's a orderly transfer of power. And this is the first time in history that this has occurred. So Jefferson, it's actually to John Adams' credit that this works. Some were a little bit nervous. First time where a transfer of power occurs in a peaceful fashion. So now as Jefferson is president, in a peaceful manner, that doesn't mean that there were not tensions that existed. One of those occurs with the appointment of judges. As John Adams is leaving the White House, it says here, just before his term was to end in March, Adams then tried to appoint 42 Federalist Judges. These are judges that would be sympathetic to the Federalist cause, and these were appointed just a day or two before John Adams' term was to expire. And so the idea was that Thomas Jefferson was going to inherit all of these Federalist judges. So we have a court case here then that exists, Marbury versus Madison. So James Madison becomes Thomas Jefferson's Secretary of State, and Marbury is to receive one of these midnight appointments. Marbury is one of the 42 Federalist judges, but he does not receive that appointment. And he sues Madison, the person who was supposed to deliver the appointments. He sues Madison, saying, when do I get my appointment? When do I get my promotion? Now, that goes then to the Supreme Court, and interestingly enough, we have a new Supreme Court Chief Justice who John Adams appointed as one of the 40 Federalist Judges. And this new Supreme Court Justice is John Marshall. John Marshall is a relative of Thomas Jefferson, but he's a Federalist, and Thomas Jefferson is an anti-Federalist. But he now is sitting on the Supreme Court as Chief Justice, asked then to make a ruling on whether or not Marbury should receive his appointment. So in your book, there's a short description of this Marbury versus Madison. Read through that, and then also there's a video, and it's a short 8-minute video that explains it pretty well. But this is an extremely significant case, especially the fact that Marbury ends up having the case dismissed by Marshall, and he establishes this precedent of judicial review. So this precedent of judicial review is key in this case, Marbury versus Madison. And I think this video will be able to explain it a little bit more precisely than I can.
It goes back to the election of 1800 when Thomas Jefferson and the Democrat-Republicans beat the Federalists of John Adams. And it's full of politics because Adams, on the last time he was in office, appointed these judges. And when Jefferson came in, he decided he didn't want those judges.
Back then, the inauguration, the change of administration, it didn't really happen until March. So you had this period where Congress was in session, but the president really hadn't changed.
In that 2 or 3 months, the Federalists and President Adams, who had just lost, they realized they're about to become the minority party for the first time ever. And both the executive and the legislative branches are going to be dominated by their opponents.
So John Adams and his Federalist colleagues are trying to do whatever they can to stay in power. So one of the plans that they devise is to expand the number of judgeships in the federal judiciary.
Adams' thought in all this was, on the way out, I'm going to appoint a whole bunch of judges and they're going to carry on my legacy.
They passed a law that is nicknamed the Midnight Judges Act.
John Adams is literally signing judicial commissions,
nominating people, getting them confirmed by the Senate,
into the waning hours of his presidency before Jefferson takes office.
And what's interesting about this is that John Marshall, who ultimately becomes Chief Justice of the Supreme Court as a part of this whole process, previously he is Secretary of State, and he's the one that physically has to deliver the commission to all of these new judges. But they ran out of time.
Whenever Thomas Jefferson comes into office, he realizes that there's all these undelivered judicial commissions for Federalist judges.
There's a stack of commissions on the desk, and Jefferson says, we don't want Federalists as judges.
And he orders his Secretary of State, James Madison, to not deliver them.
It's really a political decision that Jefferson resented the Federalists. He thought there were too many Federalists in the judiciary, and so he wouldn't deliver these appointments.
Well, one of these judges was Marbury.
It just so happened that Marbury had a friend who was the former Attorney General for the United States. And his friend said, well, there was a statute passed several years prior that allowed the Supreme Court the authority to issue something called a writ of mandamus.
A writ of mandamus. It's basically a mandate. So Congress said, if need be, Supreme Court, you can mandate that something happen. So Marbury says, I know. I'll ask the Supreme Court for a writ of mandamus, to give me the commission as a federal judge.
Now, there's a lot of irony in this because John Marshall, who was the Supreme Court Chief Justice, was also in charge of delivering the appointments.
John Marshall, who had wanted to deliver the commission to Marbury in the first place and just ran out of time.
So John Marshall gets this request. He's like, ooh, I really want Marbury to get this commission. He's a Federalist. On the other hand, I have this new administration full of anti-Federalists, and I don't want to piss them off.
And as evidence for that belief, the Congress of the United States actually suspends the Supreme Court for a full year.
This was a signal to John Marshall and the other justices on the bench that if you decide this case in the wrong way against the Democratic Republicans, against the Jefferson administration, there are going to be dire consequences.
So John Marshall is faced with a dilemma.
If Marshall rules that Jefferson has to turn over the commissions, he's going to ignore the court order. Imagine that for a second. A president of the United States, a Secretary of State, ignoring an order from the United States Supreme Court. What precedent would that set? It would make the Supreme Court an inferior branch of the federal government.
And what's remarkable about this case is the way John Marshall sort of navigates this decision.
In Chief Justice John Marshall's opinion, he essentially poses three different questions. First, he wants to know whether or not there's some sort of legal harm suffered by William Marbury.
He says fundamentally that what the president did was illegal. By refusing to deliver the commission, President Jefferson did not faithfully execute the law.
Next, he wants to know whether there's a remedy at law for those legal injuries.
And Marshall says because Marbury didn't receive that commission, he has a right to sue. And so here we are now 2/3 of the way through the opinion, and it looks like Marbury's about to win.
Then we get to that third question. Can the Supreme Court do anything about it?
And Marshall turns around and basically does a 180-degree turn and says, but we have a problem.
He decides to go back to the Judiciary Act of 1789. And he finds that this writ of mandamus was an expansion of original jurisdiction. It expanded the power that the court has under the Constitution.
What would happen if we could add to the court's original jurisdiction outlined in the Constitution just by passing legislation? Well, that means that you could amend the Constitution with any old act of legislation. Why not amend Article 1, the powers of Congress? Why not amend Article 2, powers of the presidency?
So what does Marshall do? He says, you know what? I don't think that that part of the Judiciary Act of 1789 is constitutional.
Chief Justice John Marshall reasons that the Judiciary Act of 1789 essentially amends the Constitution.
The Supreme Court doesn't have the power to issue a mandate that something happened.
Therefore, the part of the Judiciary Act of 1789, that's Section 13, that adds to the Supreme Court's original jurisdiction, must be null and void. It cannot stand because it directly conflicts with Article 3, Section 2 of the United States Constitution.
And as a result, he declared a law of Congress unconstitutional.
And from then on, established the precedent for judicial review.
Judicial review.
Judicial review.
Which is the court's greatest power, that only the Supreme Court can say what the Constitution is.
This ability to examine laws, compare them to the Constitution, and when there's a discrepancy, to actually declare that law or part of that law null and void.
It is a seminal case that defines the power of the United States Supreme Court. The Supreme Court today has the power to interpret the Constitution and say what the law is solely because of Marbury versus Madison.
One of Jefferson's first action as president was to reduce the military establishment and this was due to a Republican ideology at the time and a distrust in large standing armies. Remember that Washington and his Revolutionary War army and Washington's status as a general, that was a Federalist and a Federalist opinion about government, and a strong central government. A Republican anti-Federalist approach to government was a smaller standing army and also a smaller, less powerful government. Despite this opinion, Jefferson was faced with some trouble in the Mediterranean Sea. Off the coast of the Mediterranean Sea in the Gulf city of Tripoli, and the Barbary pirates, and the way in which these Barbary pirates kept harassing various merchant ships, American merchant ships. And so Jefferson wanted to confront this problem, and so he was forced to put together some sort of a navy, despite his better judgment about having a strong, large standing force. Take a look at the couple paragraphs on page 210 in chapter 11, and it explains kind of this reluctancy of Jefferson, but then also at the same time the harsh political realities in dealing with the North African Barbary states. So on page 211 in your textbook, it talks about the Tripolian pirates, and they had captured this U.S. ship, the U.S. Philadelphia, and they were preparing to use, the pirates were preparing to use a U.S. ship against Americans. And so in a daring exploit that ensured lasting fame, 24-year-old U.S. Naval Officer Stephen Decatur, they slipped into the harbor of Tripoli and they burned the U.S. frigate, making sure to deny the opportunity of the pirates to use this. Now this in some ways was looked at as a first action by our United States Marines, our first foreign action, and so it is referenced in the military song From the Halls of Montezuma to the Shores of Tripoli. And see if I can get this clip to work here. Couple of more images here about this Barbary pirates and action in the Mediterranean Sea, and then also the way in which in some ways Jefferson's critics mocked Jefferson. Talks about the small gunboats that Jefferson preferred instead of a great navy. And interestingly enough, this is a way in which Jefferson could, it says here, democratically distribute contracts. In other words, he could distribute the contracts to build these small ships and also win votes, patronage. So a lot of times people referred to this navy as, or these small boats as Jeffs, and a mosquito fleet. And then in your book it also talks about how during a hurricane and a tidal wave at Savannah, one of these Jeffs was deposited 8 miles inland in a cornfield, and to the glee of the Federalists they drank toasts to American gunboats as the best gunboats in the world. on land, the best in the world on land. And another important theme of this chapter is the Louisiana Godson, the Louisiana Purchase. So the last part of the chapter looks at Louisiana. So you have Robert Livingston and James Monroe sent across to talk to the French about purchasing the land. They are given permission. They are given the opportunity to spend a certain amount of money, and when they get over there, Napoleon basically offers to sell the whole amount of land. The reason why Napoleon was so anxious to sell is because of the revolution, this resistance, this fierce resistance that was occurring in Haiti. So the Louverture Revolution or resistance is sometimes referred to as the Louisiana Godson. That Napoleon Bonaparte kind of lost interest in his American possessions because of this rebellion, and so he immediately offers to sell this land, and the United States envoy takes full advantage of this and purchases Louisiana. So the Louisiana Purchase then leads to Lewis and Clark's expedition. They're commissioned by Jefferson to go and look at this land to try to see if there's a passageway to the Pacific Ocean. Initially, this voyage, this Lewis and Clark expedition occurs knowing that they will probably get into this territory that the British claim as theirs. And so if in fact Lewis and Clark are members of the military and this expedition gets into this disputed territory, it could be viewed as almost a voyage or an expedition of espionage into foreign territory. Now this is their actual route. And this is one of the most intriguing, kind of fascinating stories that you can find in early 1800 American history. A great book that focuses on this was written by Stephen Ambrose, and it's called Undaunted Courage. But the final result of this huge purchase is $10 million to New Orleans. Well, we originally offered $10 million just for the purchase of the city of New Orleans. But Napoleon is interested in selling the United States the whole Louisiana for $15 million. So 828,000 square miles. This equals about 3 cents an acre. So that concludes the PowerPoint for this chapter. Just the main 4 themes are this idea that Jefferson's inauguration, Jefferson's assumption of the presidency is a peaceful transfer of power, as incumbent President John Adams is defeated in an election. Second is judicial review, and this idea of Marbury versus Madison and the establishment of a principle of judicial review. Third is this war in the Mediterranean with the Barbary pirates, and how Jefferson has to deal with this idea of a small standing army, yet he realizes the necessity of dealing with conflicts abroad. And then the fourth kind of concept of this chapter is the Louisiana Purchase, resulting in Lewis and Clark's expedition. A reminder that all these images and videos within this PowerPoint are in the public domain, and please do not hesitate to give an email or a call if you have any questions. Thank you.